Hello, Ms. Dorsey.
Good morning, everyone.
Or no? Ms. Brooks, have we met before?
I have filled in a couple of your hearings, Judge.
Have you? Okay.
Yes.
My memory sometimes fails. Good to see you again.
Thank you, Judge. Good to see you.
Ms. Waldrop, thank you for your excellent assistance. You never fail.
Anytime, sir.
Good morning, Mr. Gale.
Good morning, Your Honor. Am I late? Oh, no, I'm not late.
Just under the wire.
I'm actually in a mediation by Zoom with David Dunn. So I have somebody taking my stead while I'm gone. So I'm here. And I think Mr. Manning, I spoke to him last night. He was traveling, but he should be on here in a minute. And Your Honor, I think I see Mr. Manning coming in, but I would also let the court know that there may be the first assistant from the district attorney's office joining us as well, Angelica Hernandez.
Okay. Okay, let's get started. Welcome, Mr. Manning. Where are you traveling?
I'm in Seattle, Judge, and we got in
about
about 2 o'clock this morning, so it's been a little bit of a road. So,
okay, I have looked at twice now all these requests for production and the objections to them, and let me just get that before me here. Say 2 or 3 things at the beginning. I don't want to spend any of our valuable time talking about sovereign immunity, prosecutorial immunity, or official immunity. Those, in my opinion, do not apply to this case or this discovery proceeding. In addition, the quasi-criminal suggestion in there, the legislature itself and the Texas Supreme Court say that these are civil cases, pure and simple. And so I don't want to waste any time on criminal procedural arguments.
Your Honor, would you allow me to put something on the record as it relates to that, just so we can preserve it?
Sure.
Thank you, Your Honor. I'm sorry to interrupt, but we would present to the court that obviously the Supreme Court has had a number of rulings on the quasi-criminal nature of these cases, And essentially they look at it in terms of what I've read as, like a juvenile case, basically, wherein you would have all the protections of the criminal law and the evidence. So we would be putting on the record that we're asking the court to adhere to those. I understand the court is not ruling with that, but just for preservation, we'd like to put on the record that we'd be asking the court to provide all of the criminal protections that Mr. Gonzalez should be afforded pursuant to that. So,
Okay, I'd like for you to send me the citations of any case that's not an old case that says this is anything other than civil.
okay.
I know Meyer versus Tunks back in '62. There may be other cases since then, and I know there's some lower court cases, a very exhaustive discussion of it. The legislature itself says civil, but you need to. I'm pretty good at reading the law if you'll show it to me.
Okay.
So I'd like you to do that. Copies to everybody else, of course.
Sure.
Could I add
What I
one
want
thing?
to do, there's just a minute. I'm gonna let you all tell me what you want me to hear. I think we can go for about an hour, and then I'm gonna take another look at all this, and I'll send you some written rulings. Probably won't get it done this afternoon, but certainly early next week, I'll go ahead and rule. Yes, you want to say something, Mr. Gill?
Just on that one point that Mr. Manning brought up, that I would point out that in their pleadings and their argument, the state has continually asserted that this is quasi-criminal in nature. So, I mean, I love the fact that they can use it as a sword and a shield, but that is something that has repetitively appeared in not only their pleadings, but all of the argument, both in chambers and out in regards to this case. So, they keep asserting that, and now they want to back off of it. But, the point is that I think the case law is correct that Mr. Manning is citing to, and we'll get those to you, but it's the state that sort of puts this to the front in all of their pleadings.
If I may,
I may respond.
may I supplement that before the response, Your Honor? Very
Yes,
quick.
sir, go ahead.
Your Honor, in fact, in the petition, there is I don't want to quote it verbatim, but there is a line that indicates that something is indicative of, quote, Mr. Gonzalez's guilt in their petition. So it has been framed unequivocally as a criminal issue, and it is functionally a prosecution, right? It's a prosecution where they're requiring him to prove that he hasn't done his job correctly, but the genesis of the accusations come from them. So it is criminal in that respect. I mean, insofar as he is being prosecuted, and the state has characterized it, as Mr. Gale has said, as a criminal proceeding by using the term guilt. So that would be the genesis of our objection. Sorry,
Dorsey?
Thank you, Judge. Specifically, this is a civil case. We are not alleging misconduct. We are alleging the incompetence, the ignorance of his official duties. It's not criminal at this point. There are no allegations in the petition, the live petition, that have any criminal consequence. There is no monetary consequence. It is narrowly tailored to removal and ouster only. So we're saying this is a criminal suit completely.
So,
I'm sorry, civil.
Okay.
I got it.
Everybody, listen up. Anybody who wants me to try this as other than a civil case under chapter 87 of the local government code, make that request, give me some authorities on it, and I'll look at it. Okay. Now, Ms. Dorsey, you said you dropped the misconduct, and
That's true.
look, just a minute. I'm looking at the last page of your second amended petition, which says D, after trial on the merits, blah, 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 chapter 87, because one is incompetent, two, committed official misconduct. You're entitled to plead both of those if you want to. That happened in the Teal case. You don't have to. It's up to you, but that language is in there.
Okay.
And so, just to be clear, if you want to go on one of those provisions rather than the other, or both of them, just make that clear, because I did notice that in just almost the last sentence in your pleading, but the rest of the pleading, I think, didn't have that. That's enough discussion of that. Yes, sir.
I was going to say, I think you're correct in regards to the prayer, and it does indicate misconduct, which they keep saying they're not pleading, but they are pleading. But there is one point in there, and I think it might be in a footnote as well, that indicates either 39.01 or 39.02, which is a theft, and they put in there that they again indicate that they're going along misconduct, but they don't necessarily put that. That was part of the 91A in regards to that because it wasn't clear, but I just want to point out there's more than just in the prayer. It's actually in the petition itself.
Okay, well, we'll see what the pleadings say when we go to trial, but right now that's the state of the pleadings and it is a little bit ambiguous. We'll deal with that when somebody raises it.
Well, we're raising that, Your Honor. I mean, we want to know.
Okay, you're
Are
not
there-
ready right now because there's no challenge to the pleadings today, Mr. Gale. If you want to challenge her pleadings as vague and unspecific, do so. I don't see it yet, but that's not what we're here for today. Okay, I raised it because she did, although I did notice that. She's entitled to go on one or the other or both or neither or whatever she wants to do. But I think ambiguity is something that's going to come back as an issue sometime. And let's take care of it earlier rather than later. Let's talk about these requests for production. Let me just say that on the first several that deal with attendance at seminars and things like that. Residences. I'm on 4 now. Present at the DA's office or the building, date's not logged in, that's number 4. Go ahead and make the case, Mr. Manning or Mr. Gale, that I shouldn't enforce every one of those. In other words, rule your objections. Very quickly.
Yes, Judge.
Listen.
If I may, they have removed from the pleadings any accusation that he's using county property to travel to this fair and just prosecution event. So I don't understand how it would be relevant at all. And I don't understand why he would need to provide bank statements to that end if they're no longer alleging that there's some impropriety with attending those conferences. But the same is true with his personal address. That's obviously a privacy issue, and there's no allegation that he's not domiciled in the county or anything that would have any nexus to any of the accusations that are being put forth. So accordingly, we think they're not relevant and won't lead to relevant evidence.
Okay, the objections to 1 through 4 are overruled. Let me look at 5. Business entities. When I saw that, I thought, well, that probably relates to being away from the office, doing other things instead of being at the courthouse, and would seem to be relevant on that, or possibly lead to relevant evidence. Go ahead and any other arguments on number 5, Mr. Manning or Gale?
Because we'd say that these are equally accessible at the Secretary of State's office. They are publicly filed documents, but beyond that, if he is not being held to task for anything related to official misconduct in that regard, then I don't see how it'd be relevant. It's the same relevance argument.
Ms. Dorsey?
There's still the allegation that he is advertising for businesses, including one that he has an interest in, under his persona as the district attorney from the office or from anywhere else, depending on the facts. So we are looking to determine his ownership interest in that entity. And it's also going to show, as you stated, other reasons for his absence from the office.
Your Honor, they're asking.
Do you have reason to believe that there's more involved than the is it Cruiser Country Store?
Yes, sir. We believe that he is the registered agent from, or at least if not now, was recently registered agent for more than one entity.
Okay. Yeah, Mr. Gale, you want to say something?
Well, I'm just gonna say, look, they're asking to produce documents that are on public filings. So they can go get whatever they think is necessary, but we don't need to handpick out and make a determination of what they're looking for. They can go get them. They can get them in about 2 seconds online. So there's no reason that we have to pick and choose what they think we should give them because they're not delineating. They're just saying, go to the records, get them for us and bring them to us.
May I respond? We have done that research, and there are a lot of Mark Gonzalez's who are registered agents. Mark Gonzalez is the best person to tell us for whom he is a registered agent.
Okay, let's look at number 6. Is there any question about his actual ownership of Cruiser's Country Store?
No,
That's what number 6 asks for.
I mean, I don't.
I'm asking Ms. Darcy.
Can you dispute?
Well, we want to confirm what his ownership interest is.
And whether his ownership interest is 90% or 99% or 5%, what would be the difference in that? It doesn't matter.
Okay, okay. Same question on number 7, Ms. Dorsey, the lease agreement or deed.
Same issue, Judge. We want to know his involvement in the store specifically, not some vague, oh, he owns part of it. We need to know how much he benefits financially, whether he does or not benefit financially from this agreement. This
And how the
business
lease
that he's
agreement will
advertising
be-
under his persona as the district attorney.
Well, it's not a persona. He's duly elected twice to the office, number one. Number two, beyond that, it's immaterial what the lease or deed would show as it relates to, one, whether he actually actualizes any potential benefits from the company, and two, to Mr. Gale's point, whether that's 99% ownership or 0.9% ownership, it's immaterial. So we don't think that we should have to provide that, Your Honor, accordingly.
Okay, let's look at number 8. Videos, etc., posts from the DA's office. Go ahead. I want you to go ahead and argue that, Mr. Manning and Mr. Gale.
Well, first, Your Honor, the district attorney's office actually has a official social media account. So this is one extremely vague because it doesn't specify whether she means from the district attorney's office, from Mr. Gonzalez individually, or whom she's referring to, number one. Number two, all of those, just like the public documents, are publicly accessible because that district attorney's page is open to the public. So to Mr. Gale's point previously, I don't know why we would need to marshal evidence that is equally accessible to them. And beyond that, I don't know how we're supposed to identify which posts they are alleging are posted from the DA's office as opposed to some other location.
Now it says posted from within the physical location of the DA's office. That's not specific enough.
Well, and that would include every post from every person and every entity within the DA's office, not necessarily Mark Gonzalez. So they're asking for all, I mean, what is it? Is it something in regards to the country store? Is it some kind of Facebook post? Is it something regarding wins in trial by the, child unit? Is it, I mean, it goes on and on. They just say, give us everything.
How about that,
And-
Ms. Darcy?
Yes, sir. And we would have loved to conference about this to provide some clarification, but we were not provided that opportunity. We are looking for videos done by Mark Gonzalez, recorded by him, of him, from the DA's office. Now, not all of those videos, we cannot rely that all those videos are still available on Facebook. We sent a preservation letter, but we don't know if it's been complied with. So we are asking for all the videos that were sent out at some time during this term by Mark Gonzalez from the physical location of the district attorney's office.
Well, Your Honor, Ms. Dorsey's office writes the request. If they didn't write the request for that, then we shouldn't have to provide it. That's not how the request is written. It says all social media posts. It's very nebulous, and she may try to refine that now, but as it was propounded to us, it doesn't identify at all what she's looking for in particular.
Yeah, and I take it you all are not talking in person about these or on the phone?
No, sir.
Okay. That's ordinarily civil judges require that before they'll even set a hearing, but I haven't done it. Let's look at number 9. Okay, these policies, you got a whole bunch of requests for various policies. And I guess that goes to the supervision oversight allegation that you've got, Ms. Dorsey?
Yes, sir. We're not, and I want to be clear. We don't know what the policies are. We don't know that there are policies. Our concern is not necessarily, or we've talked about not invading the purview, of the discretion. We simply want to know that there are articulated policies, and so far, in fact, in the initial disclosures, they've stated they don't have any documents responsive to anything. So, I mean, if that's the case, then we'd like to pin it down and say that that's the case. If there's no documentation of any policies, we're happy to have that pinned down.
I think, can I say something before we go too much further?
So I want to hear from both of you. Go ahead.
All right. In regards to policies, and as we start getting into these, I think there's something that needs to be clarified. And Ms. Dorsey continually now asserts that this is a case against Mark Gonzalez in his official capacity. But as we go through these and we're talking about, please give us all documents regarding dismissals or otherwise, and we start talking about sovereign immunity or prosecutorial immunity or the protections that may rely on regards to those cases, we got to remember that what they're trying to do is get information from the Nueces County District Attorney's Office now. So to the extent that they are going into that, Nueces County District Attorney's Office is what? It is a third party. It is not a party to this case. According to them, this is a case against Mark Gonzalez. And if they're looking at discovery from somebody beyond Mark Gonzalez, which is what we're talking about, or we're about to get into, then they're talking about a third party request. And I think it's implorable it's important that we have somebody from the district attorney's office, the attorney general's office, or otherwise somebody, whoever would handle that. And I'm going to leave that up to them. But, we're losing sight. They want to use these as a sword and a shield, and they want to come back now and say this is against Mark Gonzalez. But what they're doing is asking for documents beyond that from the district attorney's office itself, which I don't know of any case in which anybody has ever gone and taken over the DA's office. I said during our conference when we were talking about this in chambers that they were going to look for everything in the kitchen sink. They're asking you for discovery in regards to issues that they dropped out of their complaint, and you're allowing them to get that anyway to see if they can throw it back in the complaint now, which I don't think really serves the gatekeeper function. But they're going to go into things that we think should have been granted in regards to the 91A, especially when it comes to the discretionary ability. And now they're going to go against the DA's office to get all of these documents. And yet they're going through his attorneys and him to get those things. The DA's office is a third party, period. And they have their own protections. And so she's about to say, but it's Mark Gonzalez and he runs it. Well, they have asserted over and over again in this hearing that this is him in his individual capacity, but everything they're requesting is not in that capacity. It's in his official capacity and it's for the DA's office. So I just wanted to clarify that and put it on the record as we start going through this, because I think they're way off the mark in regards to what they think they can get. And they're going to request every single dismissal that's ever been lodged.
We'll get to dismissals a little bit later. Go ahead and respond to that, Ms. Dorsey, and then I have a question for you.
Yes, sir. This is a suit against Mark Gonzalez in his official capacity as District Attorney of the 105th Judicial District. He is in possession and has the right of possession to all of those documents if they exist. And we are asking that he produce those documents.
Okay. Now, on these policies, and there's, half a dozen or more that you're asking for, and communications, is your concern that if you don't want to be ambushed, if he comes in at trial and says, hey, I supervise, look at this, we got policy A, policy B, or, there are other ways to handle that than to ask for production of things from the DA's office.
Well,
is that your concern, or are there other reasons that you'd like this information?
Well, yes, sir. We'd like to have this information, one, to know that he, what he's going to say his supervision is or was. We've asked for several different types to go at that angle. Are there corrective actions taken? That's something a person who is leading an office would do. Are there policies? So far, they've said there are none written down. If that's the case, then we can follow up in the deposition, but absolutely, we don't, if they exist, we need to know about them before trial.
Mr. Gale and Mr. Manning, it seems to me that if there is policy A in the DA's office, in the Oasis County DA's office, maybe that policy was there 2 or 3 administrations ago. It would seem to me that Mr. Gonzalez has access to it and he's got it. I mean, it's something that he administers, and why wouldn't he be the person to produce it?
Well,
if it exists.
If you look at the request for the policy, it says, what policy, if you're going to recommend community supervision over deferred adjudication? First of all, Jenny Dorsey was involved with the training department. She was the person responsible for the training at the DA's office before 2021 or so. That's why she limited to that specific point. But so what kind?
Actually, we limit it to the term that's available and relevant to the lawsuit.
Yeah.
Everything they ask for starts with January of 21.
Well, that's when it serves them, and we don't know necessarily the evidence is going to be limited to that. And I don't think Ms.
We'd be
Dorsey,
happy to collect evidence from the prior term.
so.
No, go ahead.
My point,
Of the law, absolutely.
Okay, everybody, listen to me. Mr. Gale has the floor. Go ahead.
in regards to the specific point, it says, list out what you would require in regards to whether you're going to give deferred adjudication or community supervision. But again, it goes back to the discretion. The DA's office has complete discretion to make a determination whether a case is dismissed or not. And the determination on whether it's for community supervision or deferred adjudication, what possible relevance does that have to any of their claims in regards to this case as it would have to their claim? It doesn't have anything. Because so we come up with a policy that says, well, we're going to give deferred in these limited situations and we're going to give community supervision in these situations. What does it matter? There's no claim that even remotely attaches to that. That what, he was derelict in determining probation in one case as opposed to deferred adjudication. That's completely within the discretion of the DA's office.
Okay.
Absolutely. May I respond?
Let me, as I read her petition, the terms supervision and oversight are in there, and there's a little bit more allegation about that. And I can see how Mr. Gonzalez would come in and say, you're saying I didn't supervise, didn't exercise oversight over my office. Look, here's policy A on whatever it is. Here's policy B on the next thing. Here's policy C, written. Went to, people signed it, or, it's, I did this, or, I did the same thing my predecessor did. I don't know, but I can see that happening. And even if I don't let her get into the actual dismissals, the supervision aspect, it seems to me, could be in the case, even if the analyzing dismissals, there were too many, or whatever the reasons are. Those could be different. Supervision as opposed to the actual conduct of dismissals. So, I mean, that's what when I read this, having read the petition in light of it, that's what the thought that came to my mind. And respond to that, please. Mr. Manning or Mr. Gale?
Well, first, if I may, Judge, I mean, one of the problems is you could give 10 different district attorneys the same file, and they might make 10 different decisions, and they may administer their office 10 different ways. So now the state is asking for all of the policies it can find to try to allege that he's being incompetent. The problem with that is it's all couched in his constitutional authority to administer the office. And to Mr. Gale's point, I mean, if the idea is you're going to find some policy to say, in situation X, they were somehow derelict because they didn't give probation or did give probation as it relates to situation Y. In some other context, it's still problematic because it all flows from the authority. And all the conversations that we've had about this case have been, how do you balance his constitutional and statutory authority to exercise discretion with the state allegations? And I think the problem.
I think I see a difference between how dismissals were done during an administration. That's one thing. A different thing is, is there a policy that shows I'm supervising and giving some guidance to my team? Those are different things, are they not? At least That's what I think of as I look at this. Now, this particular request doesn't go into dismissals themselves, probation, community supervision and so forth. It goes into, do you have, produce, if you have it, a copy of written or typed policies on this?
And Judge, while I understand that, I don't want to belabor the point. The problem is the Code of Criminal Procedure, Article 2.01 says that a prosecutor's job is to seek justice. The reason that becomes a problem in this context is because a prosecutor could theoretically write no policies and say our job is to seek justice as codified by the Code of Criminal Procedure. That's it. And you can't extrapolate from that then that they're somehow incompetent if the law requires that affirmative duty. So our concern is that this creates a scenario where he's got the authority to do this, but these policies are somehow going to be used as a sword to say he's incompetent. And that's the concern.
Okay, but look, I'm going to have some decisions to make at trial about what evidence comes in and what evidence is excluded on just the kind of things you're talking about. This asks for written policies if they exist, and if they don't exist, the answer to this is very easy. We don't have any. And if there are written policies, maybe 2 pages or 25 or whatever, then they exist, and whether they get admitted into evidence or not, I don't know. But Ms. Darcy, go ahead and let me hear from you on. And I'm going to deal with these policies as a group, and I'm starting with number 9. Is communications. 11 is policies and communications. 12, pretrial diversion. Just policies generally. I have no idea if there's a single email or policy in writing or a whole bunch of them, but admissibility is not the issue today. Relevance, that's for trial. Okay, Ms. Darcy, talk to me about policies, then I'll want to hear from Mr. Gale and Mr. Manning again on policies generally.
Yes, sir. If the policy is referred to the do the right thing, that's what we need to know. If there is a written policy that is a guideline, I'm telling you now what the policy, I'm sure there's a universe where the policy could be offensive in some way or shocking to the conscience, but regardless, it's probably one of those various things that Mr. Manning says, this is how one is going to view it. That's fine. That's within his authority. But is he providing that guidance? Is he providing leadership? Is he providing guidance on how to accomplish the right thing to his office as he should have done? And if he is, great, let us know. Let us see it to know it exists. If he doesn't, then we'll like that pinned down for trial.
Your Honor.
Yeah, I want to see how far this goes. I'm on 15, logging storage of evidence. 16 is Michael Morton and Brady versus Maryland. 17, crime victim rights. I think 18 we start getting into complaints. So this is through 17 different policies. Yes, Mr. Gale.
Just real quick, and I want to point out something that as Ms. Dorsey is going down this rabbit trail, we anticipate not only having her as a witness in trial, but including her as one of the depositions we're going to take. If she was in charge of training, then we would like to know, we know the answer, but whether or not she suggested that any of these policies be enacted, or if she authored any and proposed them to Mark Gonzalez or anybody else at the DA's office. And if she was the one that was trying to train people to do the very things that she's now asking for discovery on, I just want to point out that what's good for the goose is good for the gander. And she, of all people, would have knowledge of that. And I anticipate her answer is going to be that she didn't do any of those things. But that aside, I would also point out that I think that eventually it's just going to come to it, is Miss Dorsey probably is conflicted in regards to this case. from participating as a witness. And she may say, I don't want to be a witness and I want to confine everything to a particular time period, but she just can't simply do that. And I think it is purely relevant to this. And so I want to point that out before this goes too much further, because that is going to be the inevitable result. I told you during the conference that we had in Chambers that she was going to ask for everything in the kitchen sink, and they said they weren't going to do that. And here we are. They did. They asked for everything in the kitchen sink and the next door neighbor's kitchen sink. So, you know, I also anticipate that there's going to be a very real defense in regards to this case, at least through some of the witnesses that were even before 21, because you can't just say, I want to take it in a vacuum. Could you just tell me Monday through Thursday what you decided in regards to these policies, or is it something that has been going on forever? Are these policies that existed well before that or anything else? So I'm not sure what my university is nodding for, but I just want to point out that that's probably a very real possibility. And I would suggest that she think about that, so that whatever comes in regards to this case, that it doesn't have to be done again, and that we don't have problems not only with ethical responsibilities, but with, you know, our responsibilities to this court.
When did you leave the DA's office, Ms. Dorsey?
I left there the end of 2020.
Okay,
And may I respond?
yes.
Well, I very much appreciate Mr. Gale's attempt to intimidate me and affect my job as the state. I'm going to go forward. And I will note that if Mr. Gale and Mr. Manning are in agreement that the previous administration is open to discussion, then I am happy to do so. And we can include and increase our discovery requests and our presentation of evidence.
Any such agreement by you all would have to, I'd have to be a party to that agreement, wouldn't I?
Perhaps you would, Judge.
I think I'd have to sign off on that before it happened. What else about the policies before we move on?
It's either they exist or they don't, Judge. It's a sign of leadership. And if he's going to produce it at trial, we'd like to have it now.
Okay. Mr. Manning or Mr. Gale?
Well, if the court orders that, we'll gladly provide it. We would just ask as a counter that we be provided all written policies from the county attorney's office as promulgated and put together in this current term. I mean, the only way that a jury is going to be able to make any determination as to whether someone is appropriately leading an office, if the allegation is the existence or lack thereof of policies or somehow proof positive of that, then I think they should be given the barometer of any such office, particularly a prosecutorial office, particularly Ms. Dorsey's office. So we'd ask that the court order Ms. Dorsey to provide us with every single policy that her office has, written or otherwise, so that the jury, if it gets to that point, the jury can determine whether in fact he's exercising the same standard of care to which she holds herself.
Okay. You'll need to make that request in writing, and I'll take a look at it when it happens. I'm on number 18 now, complaints by outsiders. Families, law enforcement.
I mean, apart from the fact that that would be just completely impossible to recreate, you know, I mean,
Yeah, let me ask Ms. Dorsey, defend that request.
Well, I mean,
I don't know how you do that.
because if there is a person there supervising and taking part in the office, I anticipate that there should be a body of complaints that say, where's Mark? I need to talk to Mark. I haven't heard from Mark. I'm trying to see Mark. If those are something that they have, I think it's evidence that he is not participating in the office nor leading the office. It is not so much something that someone in the district attorney's office needs to sit down and look through. Although it's probably not that difficult, I understand they are strapped. They could ask the IT department to do a word search for them. Elected officials do that all the time when complying with PIA requests.
Okay.
the request,
Yeah, go ahead. Mhm.
I
Yes.
mean, the request in this just says, tell us any complaint in any case that's ever been handled. I mean, that's ridiculously vague. It's impossible to handle. We don't keep the kindergarten file on Mark Gonzalez and put it in his file every time somebody complains. And it doesn't even indicate who's asking. I mean, just because somebody wants to talk to the boss doesn't get to talk to the boss. I'm not sure what that leads to. And I would point out, as we did in Chambers, is that we have a concern that when we did do a weird search in regards to any emails that were sent to or from Jenny Dorsey during the time period that she worked with or through the DA's office, that they are all gone. They're all gone. And so we addressed that. That's still not changed as far as my information is concerned. So somebody has gone through and spliced out anything that concerns Jenny Dorsey or any of her communications while she was with the DA's office, which goes back to my point, which if she was in charge of training of these very people that she now wants to know what the policies are to train them to do things, then we're entitled to not have the emails basically stolen from the DA's office. I mean, she may be smiling, but that is a truth. And so we're looking into it to see how this could be accomplished or why it would be accomplished. And we haven't gotten the response back yet in regards to the IT department regarding that. But again, we will raise that issue in one form or another very soon. But as far as these communications, we have no idea what they're pertaining to. There is no way to comply with this whatsoever, and it is extremely vague.
May I respond?
Let's move on to request number 21.
Judge, some allegations were made against me. Could I have a brief moment?
Yes, go ahead. By the way, I just, this is a discovery hearing on 39, I believe it is, request for production. And what you all, Mr. Gale and Mr. Manning, might want to do in the future, and in the way of going back after her, I think it's best not to hear that now. If y'all want to do that, put it in writing, and I'll decide whether to have a hearing on it.
Yes,
Yes,
sir.
But to talk about that today, I think is a distraction, but I'm going to let Ms. Dorsey respond. Yes, ma'am, go ahead.
That was said by Mr. Gale in Chambers, and he's had lots of time to talk to IT in between times to find out an answer instead of continuing to make baseless allegations.
Our allegations aren't baseless, but I'll wait for the appropriate time.
Request number 21. Anything to add with what we've already said about policies and complaints and things like that?
It asks for any inner office expectations of, I mean, let's see, let's read this. Ask for any bulletin board.
No, let's don't read it. I just read it. Let's move on to number 22.
I mean, at 22, I mean, at some point, it seems as if we're, like I said before, we're really getting to the issue of the district attorney's office and how it functions. It's almost like a security issue. I mean, at some point, they have to turn over their entire training program to somebody that used to be in charge of the training program. And I'm looking at this, the training of all new employees and continued staffing. What is it exactly? They want every single thing that we've ever communicated to our employees regarding every single case and every single type of case and everything that they could possibly be, at some point come to face. That's just an impossibility. People are trained, and especially when you're dealing with a DA's office, almost every day. There are communications in regards to particular cases. There's communications in regards to particular programs. There's communications in regards to what's expected of them or otherwise. I mean, that is something that occurs every day, all day, in every case. And so again, they're looking for the kitchen sink, and they're just asking for everything that shows how your office is run, period. But their complaints, while we think the 91A should have been granted in regards to if not all, but a majority of those things, I understand the court's ruling, but that doesn't mean that the DA's office has to just open their doors to Miss Dorsey to come in and run them.
I haven't made a ruling yet. I thought she said 21. Let's response on 22, Ms. Dorsey.
22, that one is regarding the education. Okay, we want to know if there are policies. If there are education things, it defies logic to say because there's too much of it, we're not going to show you any. If there's not any, if there's no communication, let us know. We don't necessarily care unless it's egregious and contradictory to law what the policies are or what the training is. Does it exist?
I'm sorry, Your Honor, but I have to say that I don't think.
Just say, were you finished, Ms. Dorsey?
Yes, sir.
Mr. Manning?
Yes, Your Honor, I appreciate that, Judge. That's exactly the concern. She just said that she says, oh, we don't think that we're gonna, as long as it's not contrary to law, we're gonna have an issue with it. But the whole reason this fishing expedition is going on is to try to find the evidence to substantiate the allegation that they're already making. And the problem with this, Judge, is the way the DA's office is run is there's 45 prosecutors there when they're full who generally, because of the way the law works, have autonomy on their own individual cases in a lot of respects. So to try to get us to marshal every single potential email that could be sent like that is impossible, particularly where there are already issues with emails from previous people working there. So I think it would need to be refined, number one. But beyond that, Ms. Dorsey, being a county officer, has the same access to IT to get them to marshal that evidence for her. As we've said, she can access that. So the same way she says we can contact IT, she literally works with IT. She can ask IT to run that information. Why we need to provide it, I don't understand if she's got equal access to it.
Let me ask this question. I mean, it's common in civil cases for each side to ask for documents and things from the other side, because they want to know if an exhibit is going to be offered by the other side. Look, here's what we did. Aren't we good? They want to know about it. How much would it raise the comfort level for you, Mr. Gale and Mr. Manning, if Ms. Dorsey were to, or if I were to require you to say on these requests for policies, training, and things like that, Mr. Gonzalez, if you're going to introduce documents showing, look at the training we did, we had a policy on this and that. If you're going to do that, Ms. Dorsey is saying, I'd like to see it and get a copy of it. But if you're not going to do it, if it doesn't exist or you're not going to do that, that might satisfy her. Talk to me about that. In other words, I could require on what we've been talking about for the last 15 minutes.
I think
maybe it would be enough if you all were to say, we don't have that, or we're not going to introduce anything like that.
I think
that would solve the production problem, wouldn't it?
It may, but it goes back to the problem that I see that, if let's say a defense attorney in a criminal case wanted to send off an open records to the DA's office to find out all their policies in regards to making a determination on what kind of punishment or what kind of probation or anything else was involved. Do you think that they would get that? No, it would be protected under the Open Records Act, and it wouldn't be subject to it because it would involve in the internal workings of the DA's office and wouldn't be available. And so they're wanting to get all these things that otherwise wouldn't be public record and shouldn't be public record, because what Mr. Manning keeps saying is that there's a discretionary element to not only the decisions to prosecute a case or not, but also as to how you prosecute that case and whether that discretion is followed. And I mean, that you cannot dictate those sorts of things, but we keep coming back to it that Nueces County is really a separate party in regards to this. I mean, Nueces County District Attorney's Office is a separate party. It's a third party to this case. And so even if
there is such a policy, wouldn't Mr. Gonzalez be able to get a copy of it from Nueces County and introduce it into evidence?
What I was about to suggest is even if this court overrules our objection and does force him to do that, that it should be under some sort of protective order, which would preclude its use in any form or fashion until otherwise ordered by this court. Because we still want to, there is still a DA's office there. We forget that they're trying to do a job, and these sorts of things should be protected. I don't think they're useful in regards to the case. They shouldn't be. And I think that the 91, when you heard me say, I thought you ruled on the 90, I said 91A, not 21. But so that's what I'm kind of thinking, is that even in regards to these policies, is they should be under a protective order, because there's nothing that would make those public record, period. And a lot of the things that we're talking about are still under those guys as well. And I don't know if Mr. Manning agrees with that, but
I absolutely agree, Judge. And the only other thing that I would add to that is that, even if those policies are potentially public and not necessarily something that would be exempted from the Public Information Act request, the concern is still that that doesn't prove incompetence necessarily. And that's a huge issue, to require them to marshal all these policies to then decide whether you think those policies are deficient or insufficient. The existence of the policies is really immaterial. And that's my concern. I think we're going to go into that same place that we've talked about several times.
I would just point out too, that in regards to their complaint is very limited in regards to the examples that they want to use to get discovery to show this policy. I mean, they have very limited thing, and most of their evidence concerns the defense attorney's accusations. I mean, well, of course, defense attorneys are making accusations regarding things. The other one that they had was the failure to try to ask a judge, who the judge makes a determination on this, to either continue somebody on probation or not, led to dire results. Well, that's always a possibility in regards to any and all cases, but they're using that as some sort of example. One example of a completely discretionary thing that would eventually be up to a judge to make a determination on, to get full discovery in regards to every single case that could possibly be like that. And at the end of the day, if you multiply discretion, which gives you about 0 materiality in regards to the issues in this case, and you multiply it by 1,000 times that that's ever occurred, you still got 0. And so there's still no materiality in regards to whatever their claims are. And so that's our concern in regards to that. And when you're looking at this, I think I'm not sure if we're on 23 or 24, but you're looking directly into those. But on 24, you're talking about, please give us anything that has disciplined, corrected, redirected instructions on work performance or anything of any employee for any reason. I mean, that is just impossible. And it's overly broad, it's vague, it is purely meant for a fishing expedition. And while we said it's common to get discovery in regards to a claim that you're making, it's not common to get discovery to make a determination on what your claims are, unless you're talking about a 202 discovery petition in state court or something, which we pointed out before. They didn't bother to go do all that. They just want to put the cart before the horse, and they want to do all this discovery regarding everything, even if it's something that they dropped out of their amended complaint. Their live pleading doesn't even contain a lot of things, and yet their discovery that you've granted them ability to do allows them to do that. And I don't quite frankly understand that. It's not common. It is common to get discovery in regards to your claims. It's not common to just go on a pure and utter fishing expedition to make a determination on what you're going to claim at some point right before trial.
Let's move to number 26. Mr. Gale and Mr. Manning, talk to me about that one.
Because this is a big problem as it relates to the Board of Judges meeting. Mr. Gonzalez has no statutory duty whatsoever to appear at the Board of Judges meeting. So any communication related to that is completely immaterial to anything. If the state's going to try to imply that his lack of appearance at any Board of Judges meeting is somehow tantamount to failure to do his job, that is a reach as far as it comes, because he doesn't have any duty to go to those meetings. So for all the same reasons we've mentioned, without belaboring the point, I don't see how this is relevant to anything, whether he went to the Board of Judges meeting or not.
As an aside,
Ms. Darcy?
Yes, sir. We're not claiming that he has an obligation to go. We are looking for the emails that he named in his own responses earlier in public, that I told them I was not going to be there. I sent you the email. Don't you have the email? And it all goes to the absenteeism, Judge. It's another way of showing that he's not participating in the office.
How can you be absentee to something you have no duty to be at? You can't be absentee. You have no duty to be there. So to try to extrapolate from him not being there that he's somehow doing derelict in his duty is an absurd notion. You have no duty to be there. They can ask him to come. He doesn't have to come.
As an aside, Your Honor, he did have somebody there in his stead that was participating in the hearing, I mean, so yeah, Mr. Manning's right. I mean, he just has no duty. So you're gonna go backwards and say, well, we'd like to get his emails explaining why he wasn't at this meeting that he didn't have to be at, that he had somebody else appear in his stead anyway. I mean, it's all immaterial.
It shows his absenteeism, Judge,
From what?
Ms.
from
Darcy,
anything to do with the office.
Ms. Darcy probably, when he's on the witness stand, he would admit he didn't go to those meetings. If he claims he did, wouldn't one of the judges be able to come in and say he wasn't there? I mean, if his actual attendance or non-attendance is the issue, this is a little different, asking for the correspondence.
Well, Judge, it's, there's one thing is to be in your office and decline to go to a meeting to which you are not required to go. Another thing is to say, I'm sorry, I'm going to be in the Bahamas for the next week or so I'm not coming to your meeting. That's part of the absenteeism.
No disrespect.
If he said something like that, wouldn't one of the many judges have a copy of that?
Well, Judge, it's unclear to me whether or not you're going to allow judges or require judges, district judges, to testify.
Okay, well, I think I understand this, and let's move on here.
I mean,
I'm reading, Mr. Gale, just a minute. I don't think we're gonna have time to talk about every single aspect of these. I want to pace ourselves. I'm on 27. Ms. Darcy, I'm going to give you a chance to defend that one. 27.
Well, Judge, we believe that there are probably reports because they have to report, the fees and the amounts and things. I'm not looking for a file of each of these things. I'm looking for a report that shows who all went into the pretrial diversion program, which offense, especially which office is qualified, as that goes to a policy and oversight, and the number and type of offenses. It's purported in the community that these are, one type of thing. And if that's being followed, I mean, whether it's being followed is a type of oversight.
May I respond to that, Judge?
No need to. I've told you all at the beginning that I wanted to have discussion of these, and then I would look at things again and give you a written ruling. I'm sustaining the objection to request number 27, overly broad, unduly burdensome, etc., not leading to the discovery of admissible evidence. Sustained. Let me look at 28. I'm sustaining the objections to 28 without argument. Let's look at 29. This deals with policies, does it not? And we've already, I think, exhausted that subject.
Yes,
well,
sir.
I think it goes a little bit more beyond on this one in particular, especially.
Okay.
I mean, obviously, in regards to any case that's dismissed, whether it's 1, 5, or 1,000, the discretion in each is absolute. And so it doesn't really matter how many dismissals you have. And yet this one says, give us your policies on dismissals of criminal cases. That's number one, that's extremely, extremely vague. Do they mean do we have a policy that says when you dismiss a case, you need to fill out a dismissal form? Or is that something that just logic would dictate that would be done? I'm not sure what they're asking in a policy of dismissals. And so we don't even know how we would respond to that in any fashion. But at the same time, who cares what the policy is? Mark Gonzalez or any other DA in the entire state of Texas have complete discretion in regards to what cases they dismiss, period. And so whatever their policies are on why they dismiss, or whatever their policies are on why they don't dismiss, is completely irrelevant and shouldn't be allowed.
So if it exists, sorry, Judge.
Go ahead. I was gonna ask you.
So if there is no policy, written policy regarding dismissals, tell us and we're done.
I like Miss Dorsey telling me what to do, but I'm gonna ask the court to do that.
Okay, let's talk about number 30. Let me ask this. I'm aware of the recusal or disqualification in the case that Ms. Wood was involved. That was the one, was it not? Or was there a different case where he was allowed to recuse?
I think what they're fishing for.
I'm asking a question here. How many times in this 21, 22, and 23 has Mr. Gonzalez recused or got permission to be disqualified in a prosecution? How many times has that happened?
Several. And
Okay.
can I explain why?
Yeah, okay. And do you all claim that that's part of this case, Ms. Dorsey?
Yes, sir. There, potentially, because we're trying to see what the policy is, and perhaps we need to extrapolate it from what the actions are, but is there a guiding principle that was provided by the leadership, particularly Mr. Gonzalez?
Again, Judge, anybody who's worked in a prosecutor's office knows that it's always an ad hoc determination as to whether the office has a conflict or it's appropriate to recuse. You cannot extrapolate from that somehow you're not doing your job correctly if you take an ad hoc approach and there's no policy, or if there is a policy that there's somehow a bad policy. We're wading into the waters of he's got constitutional authority to do his job. And this is not relevant to anything beyond trying to make a case that you otherwise can't make. I don't understand how that would be relevant to anything. And if
Your
that's,
Honor, I'm sorry.
go ahead.
I hate to jump in, but real quick, I mean, a lot of the, in regards to Mark Gonzalez, he used to be a defense attorney. Him and Mr. Manning used to practice together and used to defend cases in Nueces County. So if a person comes up to the DA's office that was once the client of Mr. Gonzalez, then of course the law obligates him to bow out of it, and they'll get approach him or have somebody else or the Attorney General's office. So what? None of those things are relevant. I mean, they've got the case that they want to address, then fine, but they have no claim in regards to, now we're going to look and see if there's information that Mark Gonzalez has refrained from too many cases, or how many because he has a conflict. Therefore, he shouldn't have even run for office because he had too many cases that would cause a conflict. Well, that's always going to be the case, especially when you're dealing with a town like Corpus Christi, and that's just how it goes.
In a pretty good sized office like this, is it possible for him to be walled off and, the office handles the case, but he doesn't touch it?
Not
If
the
it's somebody that he represented before.
not the district attorney himself, Judge, obviously, because all of their authority flows from him. But the court well knows, in full candor, I also worked at the office. I was the first assistant, and there were a number of cases that I was walled off from, right? That I had separately from Mr. Gonzalez in our private practice. So that is true as to any other ADA, they can be walled off, but not the DA, because all of their authority flows from him.
Is that case law or is that in the CCP?
Case law, I think.
Okay. Ms. Dorsey, your argument?
That has been our practice as well, Judge. For the head, the whole office is recused from that. But it's the same argument over again, Judge. Is there a policy or not? It is likely that a policy would exist given what Mr. Gale has already articulated. Hey, for people who I've represented, or do a search for these people, this is my direction. Recuse us from these types of cases.
But they don't have a claim.
Okay, let's move on to 32. Isn't 32 related to all this? I mean,
32.
32 and 33, special prosecutor, attorney pro tem. You wouldn't need that unless there'd been a recusal or disqualification.
Not necessarily, Judge, because they could bring in a special prosecutor if they deem it appropriate, but it's the same issue. It's still, meaning there's no conflict and they think this
Okay.
other person's appropriate to prosecute, but same issue.
Okay. Let's look at 34 and 35 deal with lost evidence. And the allegation, Ms. Dorsey, is that he wasn't supervising, clued in.
Yes, and because of that, there may have been things that were actually lost.
How many cases do you say that happened in?
I have been approached on 2 so far.
I mean,
Mr. Gale, Mr. Rainey?
I was just saying, the request might be different if we could have a tangible case that we're talking about, but they don't. They say do a search on, let's say, sieges. If I do a search regarding sieges with the DA's office or any judge or anybody else, you're going to come up with 100,000 emails regarding sieges. I mean, all of these things this is not a request for policies or anything. This is go look for some search terms for us to do some searches on this or that, but they don't give us anything to lead on. I mean, just as an aside, there has never been anything lost. But in regards to these cases, they don't give us anything tangible to work with. They're purely going on a fishing expedition. They're just throwing it out there. Judge, can you make them go do a search for anything and everything that they could possibly go get? Maybe we could find something of use that will help us figure out if we even have a claim to begin with. I mean, they don't, but we can't comply with these things and we shouldn't have to. They're just ambiguous and vague, and it's exactly what it is. It's a fishing expedition.
Okay, I want to move on to 37 now. Execution of bond and oath. You all don't agree about what the facts are. How long, Ms. Darcy, do you contend that that went by before he corrected the oath problem that you say he didn't fulfill?
I believe it was done after the filing of the suit by Mr. Wiltsey.
You all say he complied with this before that, Mr. Manning? Yeah.
Yeah, we're saying that he complied with it before, and even if you accept any argument that he didn't, then he complied with it before as well, and then he complied with it after the fact as well. I mean, either way, he's done that. But this is asking for any information evidencing the execution of your bond and oath in compliance with blah, blah, blah. So it's asking for what? Internal information in regards to us, regarding anybody with the Secretary of State, anything else. I mean, does it matter how it was faxed or how it was emailed or anything else? I mean, it is what it is. It's either on file or it's not on file. All the documents, no one's disputing what the documents are that we all have.
Ms. Darcy, do you have reason to believe that he backdated anything?
Judge, I have received several productions from the Secretary of State. Every time we asked, we received a different type of document. And then after the after the case was filed by Wiltsey, we see a form dated by Judge Stith in, I think, February of this year. So it's very confusing what the state Secretary of State has to produce, because their first production was that nothing existed at all.
Let me ask you this, Ms. Dorsey. What would, I can understand sloppiness and not paying attention to details. That might explain what you think the facts are. But is there any reason why Mr. Gonzalez would want to do the paperwork in a sloppy way on the bond and oath?
Well, I can't opine on why he would want to, but I can say that if there is, if in the previous administration, there was a failure to obtain a bond in a timely way. If that was something that you learn about in the first term, it would seem to me it would be something, if you cared about your duties, you would do correctly the second time it came around. And it appears from what we received at our initial request from the Secretary of State that it was not something he cared to do.
If I may, Judge, Ms. Dorsey has a direct conflict on this issue, as Mr. Gonzalez counseled with her after the filing of this lawsuit, from my understanding, as it relates to this bond issue. So in that instance, we would be telling the court affirmatively we intend to depose her or have her testify as it relates to her conversations with Mark Gonzalez regarding bond compliance that she's now seeking to prosecute. You cannot have it both ways, particularly if at the time he counseled her thinking he would get advice from her being the county attorney. So I don't think she can prosecute that and also be a witness in that respect.
Our office does not counsel unless asked by the district attorney. And so we don't have those conversations.
Be that as it may, the 12 people need to hear from you the conversation you had with him about the bond issue that you are now prosecuting, right?
Your Honor.
Material.
Your Honor,
Okay, just a minute. That's the kind of thing, Mr. Manning, if you want to assert that, I think you don't just bring it up in a hearing like this one, you put it in writing, put it out there, and let her look at it, and whoever wants a hearing on it, they ask for it. Witness statements, number 38. Refresh me on what the rules of procedure say about that, Ms. Dorsey. I meant to look, but I didn't.
Well, I think this is, this is kind of related to the 194s that they said they didn't have any documents for. What is your question?
What are the rules of civil procedure? The discovery rules say about getting witness statements taken by the other side.
Hold on.
Well, okay, if you're not ready on that, I'll look that up. What do y'all say, Mr.
Your
Manning?
Honor, just real quick, what she's asking for is any witness statements. It doesn't delineate witness statements that were taken as a result after the filing of the civil suit. It just says, give me all witness statements that deal with anything that you may possibly address, including in defenses or counterclaims. And so if it's something that exists that we're not going to go find, we can't find, or we don't know. There's probably about, I don't know, if you're going to give them access to all the dismissals and things, there's probably about 10,000 statements out there from somebody that deals with all this stuff, but they're not differentiating between witness statements that were taken in regards to the case itself after the filing of it. So in other words, we find out a witness, we have them do an affidavit or declaration or what have you, or even just a statement. That would be way different than any statements without any clarification or otherwise. And so I think the rules in regards to disclosures may talk about one thing, but it does not necessarily talk about the other.
I'll check the rules on that. Look, let's talk about number 39. This is more complicated. Let's look at it. Statements he's made, Mr. Gonzalez has made about this suit that there are recordings of.
I can expound on that, Judge.
Please do.
Mr. Gonzalez went on to Facebook and has continually posted about the case, videos that are inflammatory, suggesting that this is a racist party political item. Then there are, I don't know if some have been taken down. They tend to be pretty inflammatory, and sometimes they even make sorts of admissions. And we would like to have all of them that have been posted to websites, either for, say fundraising to pay for the legal fees, or just to influence the jury pool.
Response?
One, all of those posts are on his public Facebook, so they can get them themselves. They're right there.
Except for the ones that may have been deleted.
And also, you know, he is entitled to have his opinion that he is being treated differently than other county officials for whom their legal fees are paid. His aren't. He's entitled to that. The pesky thing about the Constitution is it protects your statements, even if the state doesn't like them. So him saying that it's quote inflammatory, none of that stuff is material to anything, with the caveat that if the judge puts in a gag order, that's a different thing. But outside of that, he can say whatever he wants. And it's all up on Facebook. They can access it. That's how they know they even exist. So unless they're accusing him of having taken something down, they're accessible to them equally. And I don't understand why we would need to provide what they can access.
But
Sorry.
Your Honor, even then, I would state that when we look at this, discovery is for the purpose of eventually going to the jury. And so if he has an opinion regarding this, his opinion doesn't change whether or not they can have the evidence that supports their claims.
Right.
And so if whatever he thinks is the reason is irrelevant. The jury is not told, well, why do you think this case is being, unless you're going to be attesting to the bias of somebody or something of that nature, then that's different. But you're not talking about bias. You're just talking about his opinion as to why they're attacking him in regards to this. And while I might agree, I do not agree that ever gets to the jury. Just irrelevant.
Yeah.
When's the last time you think he made such a statement, Ms. Dorsey?
Well, I think if you go into his Facebook today, you would see the videos there right now pinned at every time somebody looks it up. But it's irrelevant what he thinks about it. There are admissions in some of them, and we can't know what he's taken down. We sent the preservation to him first, and then I forwarded it to Mr. Manning after he had counsel. We just want to be able to see them because they are admissions. There are some that could be set to private. We don't have that information.
Are you or people on your side of this case not able to make copies of what he said on Facebook?
What is up there right now, yes, we have that, but we don't know what was taken down after the fact, unless he provides whatever that is. There are also separate sites that we don't have access to.
I mean, if you just look back at the request for production, that is not what their production is for. It's to produce a copy of every single audio, photographic, video, including digital or electronic means, any transcripts of any meetings, any conversations, or any event in which the defendant discussed this suit, including defenses and counterclaims. That's a extremely broad concept, and their only evidence is that there are some things that he said that they have equal access to, and that's it. So there is no way for him to comply in regards to that, apart from the point that it would involve any attorney-client privilege information as well. But there's just no way to comply with any of that, and it's all just First Amendment stuff. She's saying he thinks it's because it's either racially motivated or politically motivated. Okay, so what? So if he said those things, they're still not admissible at trial.
Again, we don't know what we don't have access to. He does. And to say that you can't produce or shouldn't produce anything because you might not have a recording of everything is still illogical.
What is it relevant to?
Okay, I'm going to call a halt. This has been a very helpful discussion. Very helpful. I'll go over everything and send you all a ruling. Okay,
Your
anything
Honor,
else, anything else you want to say? I mean, I think it's been very thorough, but I'm ready to call a halt. Yes, sir.
just one thing, Your Honor, and I'm not trying to undo your order in regards to the 91A, but I do think that when you're making a determination in regards to some of these things that are being requested, I would ask that you perhaps reconsider the 91A, at least in some of those respects. I still believe it doesn't matter how much they involve themselves in the decision-making process of the DA's office. At the end of the day, there is still a discretionary decision-making process. And so getting caught in the trees does not help you figure out the forest. In fact, it's just a forest of zero because he has the discretion. His people have the discretion to determine what cases are going to be prosecuted and which ones aren't, and how they're going to be doing it.
Yeah, that's it. Thank you very much. Okay. Thank you, Ms. Brooks. Thank you, Ms. Waldrop. Thank you, everybody. You'll hear from me.